Hello, it's Phillip Taylor speaking from Richmond Green Chambers in London, and today I'm looking at a book from Cambridge University Press, first class book, one that I really liked when I saw it. It's called Third Party Funding, Law, Economics and Policy, very much from the stable of Cambridge University Press, who are looking not just at the standard legal approach but much wider fields at the same time, which I always like with CUP publications. This book's been written by Gian Solas. I hope I've pronounced the name correctly. I think it's Gian Solas. The book, as I say, comes to us from Cambridge University Press. Elizabeth wrote this review after we had a discussion about the book, so I'm presenting it on the basis of our discussions and what we've put into the review. And the review title is Third Party Funding for Problem Legal Fees. Here's a comprehensive analysis. And more about that in a minute. Let's just have a look at the book. It's only a small book. It's hardback from CUP. There's the front, there's the spine, and then there's a bit of blurb on the back. You can probably see that. It says a little bit about Mr. Solas. He's an Italian lawyer with several years working experience in national and international law firms. He's got an LLM in European law and a joint PhD with a thesis on the law and economics of third-party funding. So this is almost certainly a development, as many of these publications are, of the thesis. And that's good because it gives us, actually, as the public, if you like, rather than trying to dig through something in the Cambridge University Squire Law Library or whatever, it actually gives us a chance to see what's going on. Now, the back of the book, it runs to 350 odd pages. The back of the book has an index. It's by page numbering. Then just before that, you've got a bibliography. Reading this, whatever you want to call it, it's a bibliography. Very detailed. A lot of information there. And of course, you've got conclusions at the back of the book. Now, what you have got is quite a lot of footnoting. You can see there's no paragraph numbering. There are subheads which are used. If we go to the front of the book, this is just a little bit of blurb about what this book is about. It says it's a standalone practice with wider litigation and legal services markets as potential readers, and it reports on legal issues relating to third-party funding. That's the basis of it. Obviously, it's got the subtitle Law, Economics and Policy, so you're mixing all three. But it's coming to us from his thesis, I think, and also it's a very substantial work. There's the blurb from CUP and a nice dedication, which I shall let you read. Now, we do not review books that we don't like. I reviewed this one because it's a very good book. No point in reviewing books I don't like because I'm just going to upset the author, and there's no point. These books are reviewed because we think they're of benefit to practitioners and researchers, and that's why we've got it. There's the actual content section. Starts with a few things there. You can see how it's structured, runs through a bit. What we then have after the contents is the acknowledgement section there. Then abbreviations, very useful in this day and age. There's always a problem in that there'll be an abbreviation. I can't quite remember what it is. So for instance, CFA, conditional fee agreement. You see, easy, you can remember it, but it's useful to have this just in case. And of course, it continues on the second page. Then we get an introduction from the author, and it sets out, he's talking about dispute resolution, of course, right at the beginning, quite right too. There is some, again, some footnoting at the front, and we go from that. It's got a lot of footnoting. He likes his footnotes, does Mr. Solas. Now we then go from there to the actual book itself. And what we've got here, I'm just going to get to the front, that's the introduction itself. And then what we do is we go from the introduction to chapter 2, which is, he says, a historical overview or an historical overview, depending on how you want to do it. Meddling in other people's disputes for profit or other reasons is not a novelty in legal history, neither in the civil law nor in the common law jurisdictions. Now read on. You see, it reads very well. It's a high quality book. And then we run through with the various chapters. Again, there's a lot, sometimes there's a lot of footnoting. And I do give you a tip, actually. Social impact, here we go, third-party funding. I give you a tip here, and that is that when you're reading the book through, don't bother with the footnotes unless you really feel you have to. It's better to get a picture of what the book is all about and an overview. And I do think that works, because sometimes to be blunt, the footnotes can be a bit wretched. But they're useful because it shows where his sources are. Now, what do we say about the book? Of ongoing concern then to lawyers as well as the general public, it's the ever-present problem of access to justice, paying for it, and being, of course, the main concern. That's hence the third-party funding idea. Because it costs, it's very expensive. Even in the last 2 weeks, I've had a number of cases where the costs award at the end have been very, very high, far higher than the parties really expected, and unnecessarily sometimes inflated, with great respect to my opponents, who sometimes over-egg the pudding so much that it's really something up to be seen, because they really do overdo what they claim they've actually done by way of work and what they claim what the costs are. And that's what we argue about in court. But you see, the problem really must be someone's got to pay for it, the losing party, in other words. And of course, whilst costs are discretionary, it's pretty unusual that the judge is going to look at the behaviour of unless it's really bad, the behaviour of the parties. I've had 2 cases where the behaviour of the parties has been appalling, and yet the judge has still ordered costs. Haven't liked it, but that's the way it is, because it's discretionary. So going to law is always expensive. Therefore, how do you, or actually your clients, finance it? If legal fees, court fees and so forth are beyond reach, especially now that legal aid provisions have been radically reduced, could the answer, or at least one answer, be third-party funding? Now, obviously they've got different words that mean the same thing, because TPF, as these sort of initials, refers to third-party funding. Hence the title, if this in what is a timely, if potentially controversial title from CUP, the Cambridge University Press. I'd like to thank CUP very much again. You do a great deal of work for us, which makes us, certainly in the academic world, and I'm biased because I did attend some lectures at Cambridge, at Sydney, Sussex, so I'm bound to be a little biased because I really do think Cambridge have a very, very high quality of academic provision, and they do make lives a lot easier for everybody, and the works that they publish likewise do the same thing. And I'm not saying Oxford's the same, because both OUP and CUP publications, I think, are really at the premier end of our publications, apart from, of course, the practitioner groups. But we're very fortunate in England and Wales to have such great expertise at our fingertips, because if you go to a bookshop, let's say on the continent, a law bookshop, and have a look and see what they've got, you'll see very quickly that we have much wider range of titles, because we look at it in a rather different way from some of our colleagues. And that's not to decry them, but it's to say that that's the way we do it. And CUP in particular, I think, have done a very good job. So according to the author of this publication, Gian Solas, third-party funding is generally defined as the professional practice of funding the costs of a dispute in exchange for a share of the sum recovered, but only in the case of victory, sometimes entailing the transfer of the claims, this not being made by lawyers of insurers. I think it could be lawyers or insurers. Now, I think that's actually, there may be a slight typo there. I think it's all lawyers or insurers. Now, the assumption here then is that the third parties who have provided the funds get a presumably pre-agreed sum of money if the case is won, but not a penny if it isn't. Now, obviously, in some jurisdictions, the issue, of course, is rather different. America, I'm thinking of in particular. Now, again, we spend a huge amount of time in the courts dealing with costs. And I think, again, that's something we're going to have to look at in the future, because I do believe it's a very large waste of judicial time. And I'm sure that some judges will probably agree with me, some won't. But I think when you look at it, the amount of disagreement on costs is really, it can take up a huge amount of time. And it's something we've got to think about, because obviously the basic principle is costs follow the event. Now that is the basis in the White Book here, and it's the basis of everything we really do in this jurisdiction. The point, of course, being made in this book is that, as with very few authors have outlined, a systematic view of this practice, which is what we're getting here, because the book now provides one, namely a static vision of the problem. And in summary, of course, Mr. Solas explains that this book is the first attempt to do a comprehensive analysis of third-party funding as a business phenomenon. And this has been floated around by the politicians, by the way, for 10 years, so don't think it's something new. Some of the politicians I met, mainly Tories, have certainly talked about this over the last decade, but we don't seem to have got very far. But we are, of course, assured that litigation funding of this nature can be applied in both civil and common law jurisdictions. And I think probably as we move into the 2020s, with the big changes that are taking place, the drop in the number of cases, the online courts, all the other things that are happening, we may be doing our business a little bit differently. Of course, the book's introduction section describes a series of funding practices that would be potentially capable, one way or another, of providing an alternative opportunity to access justice and solve disputes rather than using the party's own funds. And of course that's, I think, a very interesting starting point, because the said series includes most or all of alternative litigation funding, ALF, from legal expenses insurance is the insurance side model, to contingency fees, sometimes very, very, very strongly opposed, to CFAs, the conditional fee agreements. I don't agree with the CFAs myself. I don't like the concept. I don't like contingency fees either. My basic view is you put your money where your mouth is. If you don't like something, you've got, and you feel you've got to fight for it, you've got to recognise if you take that step that you may lose. And if you do lose, it'll cost you. I say that to clients. They don't listen. They want their day in court. When they lose, they don't like it. Now, you've got to understand that that is the problem. And even with CFAs, I think there's an awful lot of difficulty there. I don't like the idea of success fees. I find that seems to be me, jurisprudentially, to be making a profit out of what's going on. I don't like that at all. Because we're meant to be a profession and we're not meant to do that sort of thing. That's really why I have an objection to it. However, I'm not in a particularly strong position on that, because a lot of people disagree with me. And of course, the latter 2 points I'm making here, the contingency and the CFAs, have come under fire from time to time, in my view quite rightly, amongst quite a few lawyers, in quite a few different common law jurisdictions, and I don't think the argument's going to go away. There will be, and I get a lot of people contacting me asking me if I would do a CFA, no win, no fee. Not interested. I don't like the idea of doing it that way around, mainly because as I've said, I don't feel it's the right way to do it. But I'm an older person, and there are a lot of people with younger heads, more intelligent heads, who will probably see differently. It's interesting then to conclude on this point that the book has set out to explain or explore the possible circumstances in which third-party funding could be regarded as more efficient than any of these other ALF, that's alternative litigation funding methods. Obviously there are a whole series of crowdfunding and so forth, but I think it's important to bear that whole concept in mind. Now, to conclude the review, let me say this: read, note and contemplate all this if you will, because essentially this book presents a copiously researched study aimed at enabling readers to make at least a better informed judgment of the advantages or otherwise of third-party funding. And I think it will almost assuredly pique the interests of academics, researchers and practitioners alike, and anyone seeking an enhanced understanding of the ins and outs, not to mention the rights and wrongs of third-party funding. It doesn't give you any real answers, I have to say, but at the bottom line on this is that you at least have a book we haven't really seen before, looking where the law is, CFAs, etc., the economics of it, who's paying and why it's not working, and is it a deterrent to people? It doesn't mean that you've got a level playing field at all, from the very wealthy people to the very poor people, who can and who can't access justice. Then you've got the policy considerations. which the government of the day, this new Johnson government, will have to start looking at. It is to be hoped, of course, with books like this, that it raises the profile of the issues. I do recall, this is the final point, which is going away a little bit from Solas and his points, but I remember Rupert Jackson's points when he was trying to look sensibly at where we were going with costs. And I think he's brought some great things. I have met him, I've interviewed him, and I wish him the best, because a lot of what he would like to have seen achieved hasn't really been achieved yet, because there are, putting it bluntly, vested interests. And I do think someone somewhere has got to grapple with this issue and say enough's enough, because frankly, trying to assert legal rights means you've got to have a great deal of money. And that means a lot of people are not going to be able to do it. And I'm not a socialist, I'm not coming from that point of view, but I am looking at it from the basic values of a level playing field for everyone. We don't really have that. But the third-party funding, the models we might bring in, I think CFAs were thought of as wonderful. I don't personally think they were at all. Crowdfunding, assistance of various sorts would help. One thing would help, and that would be if people like the local authorities actually had proper advice centres to stop a lot of people trying to litigate in the first place. Because frankly, a lot of the litigation that we have shouldn't be litigated in the first place. But it is. That's where we are. And if it was a real world, it'd be rather different. In the meantime, thank you very much to CUP and to Gian Solas for producing this excellent book. The date of publication is cited at the end of 2019, and I'm recording this in 2020, early part in January. Now, I'm just opening it in the middle. Basic Economics of Litigation and Third-Party Funding, you see there. You see the structures, a little bit of footnoting there. You've got a bit of paragraph number. You can see a little bit of it. It's not particularly noteworthy. That's the defendant's incentives looking there. Reasons why non-impecunious parties enter into the TPF agreements and so forth. The economics of transactions, of third-party funding transactions. A nice little bit of mathematics. Although, I mean, basically, I'm not talking about mathematics. Litigation costs, you see here, paragraph 5.2.1. This is a big problem, and it is actually it is clearly the biggest way of trying to stop people, and it's basically an approach which effectively says, if you want to be stupid with the money, you've got to have a lot of money. And I'm afraid I have to tell you that I have met too many clients who they've got a lot of money, they're very stupid, and they're wasting it. And they're wasting our time as a result. And when they lose, they don't like it. They blame us, they blame the judiciary, when it's down to them. So that's something that should be borne in mind. In the meantime, an excellent book. Thank you to all. Good luck. Bye-bye.